Sexual Offences Against Children Act 2017 is an act aimed at protecting children aged 18 and below from sexual crimes. It covers all the important elements to safeguard a child against physical and non-physical offences, including grooming, touching, and stalking, which were not included in the Penal Code and Child Act 2001. Child pornography is any visual depiction of sexually explicit conduct involving a child. Child grooming means intentionally or facilitate in sexually communicating with a child or encouraging a child to sexually communicate or travel to meet the child with or without the intention to commit or facilitate the commission of an offense. Sexual assault can include physical or non-physical sexual assault. This video will then discuss on whether this new act provides sufficient protection to children against sexual offenses. Child pornography.
Hi, I'm Susan. Today I'm going to interview Miss Jessie, a child rights worker, about her view on child pornography in Malaysia today. Good morning, everyone. Miss Jessie, how do you think about the new law on child pornography in Malaysia?
Well, according to the information by the international police sources in 2016, Malaysia was ranked among the top countries for child pornography offences. Among the chief causes of concern is that our country did not have specific laws to deal with child pornography offences. The laws are scattered and govern all types of pornography under the category of obscene, indecent, and offensive materials. Even though Section 292 of the Penal Code and Section 5 of the Film Censorship Act do mention about possession of obscene materials, the provision may not be adequate to address the issue unless the law is specifically extended to include online child pornography materials and images. In the case of a Malaysian student, Noor Fitri Azman Nordin was charged and convicted in the UK court for possessing, making, and distributing pornography images of children. Observation indicates that what is lacking in our law is criminalizing possession of indecent or obscene images. Hence, the previous existing laws are not sufficient to protect children against child pornography. Now, the Sexual Offences Against Children Act 2017 has been passed, and it is a positive step towards protecting children from sexual crime.
I see. Do you think that the new law provides sufficient protection to children against child pornography?
Offences relating to child pornography is stated under Part 2 of the Sexual Offences Against Children Act 2017. Generally, I would say that the Act provides a wide range of child pornography activities as it includes exchanging, publishing, selling, accessing, and other child pornography activities. However, English law has yet to fully acknowledge the act of intentionally accessing images depicting child sexual assault in order to view the content which is considered as a wrongful conduct. Because there is no provision on accessing to child pornography under Section 1 of the Protection of Children Act 1978, as well as Section 160 of the Criminal Justice Act 1988. However, the new act in Malaysia states that accessing to child pornography is an offence under Section 10, and this shows that it provides a wider protections for children as compared to English law.
So what are the extra protection provided by the Act when having accessing to child pornography as an offence?
Internet services now provide the ability to view child pornography online, but the viewer will never possess or acquire it on their local device. In essence, a user can now view child pornography online without leaving tangible evidence of pornography on their local device, which can be found during an investigation to prosecute an individual. Child pornography is primarily produced to offer some form of sexual satisfaction to the viewer. This is arguably obtained when the images are accessed and viewed, where there is no longer a requirement to save and store these images for later use, which will subsequently make the offender vulnerable to prosecution for making or possession of the child pornography. Hence, knowingly obtaining access and by means of information and communication technology, child pornography shall be punishable. Therefore, Section 10 is designed to catch those who view child images online by accessing child pornography sites but without downloading and who cannot therefore be caught under the offense of procuring or possession. Therefore, Malaysia provides more protections for children against children pornography as compared to UK, which does not include accessing to child pornography as an offense.
I see. By the way, do you have any suggestions for the improvement of the law on child pornography in Malaysia?
Well, there is a small issue that I would like to bring up. Section 5 does not address the situations when a person unknowingly receiving child pornography and hence will be in possession of such materials. In such instances, the extent of the liability should be different from the current punishment because it was purely an innocent act. Furthermore, by comparing our new law with the Protections of Children from Sexual Offences Act 2012 in India, our Act lacks on the provisions for combinations of sexual offences under Section 12, 14, and 15, which are child grooming, physical sexual assault, and non-physical sexual assault. So I think that there is the additional part which may include in our new Act in order to provide more protections towards children. Other than that, I believe that the new law on child pornography provides sufficient protection to children.
Wow, I'm extremely enlightened by your insightful and detailed explanation. Thank you for your time and have a good day, Miss Jessie.
No problem.
Thank you.
Child grooming.
Good morning, everyone. Today, we are honored to have invited Ms. Ching Wei Tong, a child rights activist, to give us a talk on child grooming in Malaysia. Please put our hands together and welcome Ms. Ching.
Thank you, Ms. Chu. Good morning, ladies and gentlemen. It is both an honor and privilege to be able to stand here giving a speech to every one of you here, talking about child grooming in Malaysia, which has turned out to be an important issue nowadays. The existence of pedophile online in our country, as reported in local media, has sent shivers down the spines of people, especially parents in this country. Today's children are internet savvy, but these children are not old or mature enough to rationalize or filter what is right or wrong over the internet. As children can be easily manipulated, it is imperative for us, parents, society, enforcement and authorities, the media, and the NGOs to protect them against sexual predators. Since 2010, police have received over 400 reports of internet-related rape cases, of which 339 cases involve minors. Sadly, these are only the tip of iceberg. It was also hard in the past to determine whether child grooming could fall within the scope of Section 377E of the Penal Code. Although the final result in the process of luring or grooming children may amount to an act of gross indecency, applying Section 377E to grooming of children on the internet for a child pornography offense may prove difficult for the following reasons. Firstly, it has to be proved that the accused incited a child to commit an act with him or another person. It is challenging to decide exactly what grooming is. For example, talking to children could be considered legitimate in certain circumstances, even though sexually explicit language is used to communicate with each other and may not amount to incitement. Secondly, it must be proved that the act was an act of gross indecency. Due to the complexity in determining the nature of the offense, it would be testing to create an offense in criminal law that could incriminate someone for innocent actions. Thirdly, the child must be under the age of 14. According to the various new reports available, the Malaysian police have proposed new laws using the Singaporean model to make grooming an offense. Section 376E of the Penal Code of Singapore, which has been amended by virtue of the Penal Code to include an offence of child grooming of a minor under 16. The establishment of the Sexual Offences Act against Children 2017 has received great response from the public, as child grooming has been included as an offence aiming to ensure that children are fully protected so as to follow for early intervention to prevent physical abuse of a child. Prior to the establishment of this new act, it was hard to prove under Section 377E Penal Code for gross indecency, as I have stated earlier. Section 11 of the new act expressly provides the sexual communication with a child is an offence, and clear definition has been provided for the term sexual communication. Section 12 provides for the offence of communicating by any means with a child with the intention to commit or to facilitate the commission of any offence under Section 5, 6, 7, 8, 14, and 15. These two sections are intended to cover the initial stages of grooming, where an adult establishes contact with a child through, for example, meeting, telephone conversations, or communications on the internet, and gains the child's trust and confidence so that he can arrange to meet the child for the purpose of committing a relevant offence against the child. The course of conduct prior to the meeting that triggers the offence may have an explicit sexual content, such as entering into conversations with a child about the sexual acts he wants to engage when a meeting takes place, or sending images of adult pornography to the child. However, the prior meetings of communication need not have an explicitly sexual content and could, for example, simply be giving the child swimming lessons or meeting the child incidentally through a friend. The offence will be complete either when follow the earlier communications when the adult meets the child or travel to meet the child with an intent to commit a relevant offence against the child. This falls under Section 13 of the Act that criminalizes the act of meeting or traveling to meet a child after child grooming. Child grooming offences provided under Part 3 of the Act has included both sexual communication with a child and meeting following child grooming. The extent of protection is similar to the English law, which is illustrated under Section 15 and Section 15A of the Sexual Offences Act 2003, as Part 3 is also subject to Section 3 of our current new Act that provides extraterritorial protection. Extraterritorial protection is a broad application that does not only protect Malaysian children from local and foreign predators, but also making Malaysian perpetrator to be liable to prosecution for committing similar offences abroad. There is also provision that provides defences when the sexual communication is for educational, medical, or scientific purposes. The provisions was clear on its wording, and it is considered as a very satisfactory measure in protecting our children from sexual abuse resulting from child grooming. Thank you.
Sexual assault.
Okay class, today we will look into the laws relating to sexual assault against children before the implementation of the Sexual Offences Against Children Act 2017. First, Section 377 of the Penal Code on outrages on decency. These offences involve men or women against the children, publicly or privately. However, it is not sufficient protection because there is no clear limitation for outraging decency. Some say it is only defined as behavior that will be considered grossly indecent against children by reasonable thinking of the public, but it can be ambiguous at times. Moving on, we shall see Section 354 of the Penal Code on assault or use of criminal force to a person with intent to outrage modesty.
What is this provision about?
Oh, this provision will apply to sexual touching not amounting to penetration. This can be committed by men or women and is an aggravated form of assault or criminal form accompanied with a sexual motive. It is still insufficient for protection of physical assault against children because there's no definition of modesty. It's controversial on what constitutes an outrage to modesty, and it's may vary over time and according to the context.
Oh, I see. Miss, I think it seems like the penal code is insufficient to safeguard the sexual assaults against the children.
So, yes, so we have the new Act for protecting the children against sexual assault, because Part 4 of the Act has clear protection for the children as Section 14 and Section 15 define physical assault and non-physical assault on a child. Several cases have also been settled under the Act. The baker's assistant is the first offender under the Act. The accused was charged under Section 14 sub D of the Act, which stated that any person who, for sexual purposes, does any other acts that involve physical contact with a child without sexual intercourse. And next is a male teacher had encased a 9-year-old Irish schoolboy, and he was charged under Section 14 sub D and Section 16 sub C of the Act, as he is a person in a relation of trust with a boy. Also, a grandfather and an uncle of a 7-year-old girl have been charged under the Act with sexually assaulting the child. The grandfather is said to have committed physical contact on his granddaughter by touching her private parts for sexual purposes and was charged under Section 14 and 16 of the Act. The uncle is charged under Section 15 too for causing the victim to watch a pornographic video clip on his mobile phone.
Oh, Miss, I remember there's another case. The accused was charged under Section 14 of the Act for touching the private parts of a girl, which is learning impairment.
Yeah, this is the case that the accused was charged under Section 15 of the Act for actually masturbating in front of her.
Oh,
Yeah, so as we can see from the illustration of the cases, the new Act provides a wide, clear, and specific protection towards children regarding sexual assaults. Those that were unable to be committed previously would not be able to escape from the liability this time, because there is no longer issues on interpretation of what amounts to outraging decency or modesty to commit a person.
Oh,
Yeah.
so it is a sufficient protection for the children for
Yes.
sexual assault.
Yeah, these are very sufficient provisions. And that's all for our class today. See you all in next class.
Thank you, Miss.
Thank you.
Other provisions and suggestions for reform.
Good evening, everyone. I'm Rachel, and I'll be your moderator for this forum. We are gathered here today to participate in this forum with the aim of discussing the sufficiency of the Sexual Offences Against Children Act, which has just been established this year. This legislation is aimed to provide extra and specific protection towards children against sexual abuse. First, let us welcome our panelists for today, Miss Jessie, a practicing criminal lawyer, and Miss Susan, a human rights activist from Suhakam. Thank you all for coming today. Miss Jessie, do you think that the Act provides sufficient protection to the children?
Well, I think that Section 3 of the Sexual Offences Against Children Act 2017 is one of the important measures that protect all children, not limited to children only in Malaysia, and where the offence has been committed so long as the perpetrator is a Malaysian citizen, it is a sufficient protection for all children in the world, regardless of territorial aspect.
How about you, Miss Susan?
Yes, the Act has provided sufficient protection to the children when Section 17 and 18 of the Act recognize the capacity and evidence of child witness. It is different from the general principle where the court is cautious of the evidence of a child witness, and the court must conduct an inquiry into the capacity of the child before accepting his evidence. First of all, the court has to determine the child's understanding of the oath. If the child does not understand, the court has to ensure the child understands the importance of giving a truthful statement. Under Section 118 of the Evidence Act 1950, it stipulates that the sole test in determining the competency of a witness is the capability and the capacity to understand and give rational answer to the question put to them. If a child could do this, the court will accept the unsworn statement by the child. However, as stipulated under Section 133A of the Evidence Act 1950, where a child is sexually abused or neglected, the unsworn statement by a child must be corroborated by other evidence to commit the abuser. The basis of the need for corroborative evidence is the prejudice that adults have against children in thinking that they are unreliable or less reliable. The earliest principle was laid down in PP and against Mardai case that under sexual offences, it is safer to have the evidence corroborated. As illustrated by the case of Chao Chong and Tam Kai Yao, there is also an assumption that children cannot differentiate between fantasy and reality. Also, in the case of Chan Chun Kyung, it stated that children have the tendency to invent and distort the facts. In simple words, corroborations is the evidence confirming the evidence given by a child. However, in sexual abuse cases, the only parties are the children, victim as witness, and the perpetrators. If this is the case, the law seems to insist that only someone, an adult who saw the incident, can corroborate the evidence of a child. Therefore, it is good to see the law is moving away from this approach and start accepting the unsworn evidence of a child. If the court finds no reason why the child should not be believed, this is affirmed in Kasawan case, and the testimony of a child may be accepted even if there is no corroboration. Comparing to the English law, the rule requiring the corroboration of child evidence has been abolished in 1988 by Section 34 of the English Criminal Justice Act. Also in Crown against Norbury case, the Crown dismissed an appeal of the appellant convicted of attempted rape and indecent assault and held that Section 38 of the Child and Young Person Act in 1933, as amended by Section 34 of the Criminal Justice Act 1988, made it possible for the evidence of an unsworn child to result in conviction, notwithstanding the absence of corroborations. All in all, the current law position under the Act is that when a child gives evidence, sworn or unsworn, the court is empowered to convict without corroborative evidence. The tide has now shifted in favor of the child witness, who often is the victim.
You are right. It is indeed a great leap in the law to accept the testimonials of the children witness. What about the offences committed by a person in relationship of trust? I'm always disgusted when seeing people committing sexual assault to their own children.
Yeah, there is a provision added in the Act under Section 16, whereby a person who commits any offence under the Act against a child, if he is in a relationship of trust with the children, additional punishment of imprisonment for not more than 5 years or whipping of 2 strokes will be added to his punishment. Section 16, subsection 2 also provided a list of persons in relationship of trust with children such as parents, guardians, teachers, and some other examples. But it is not limited only to persons listed in the Act. I would say that it is a broad provision that protects the children sufficiently as long as there is a relationship of trust between the perpetrator and the child victim. Because it is extremely important to prevent children from sexual abuse from people that they are most closely connected with in daily lives. There is a recent case in September 2017 where a 53-year-old grandfather was charged under Section 16 of the new Act for committing physical contact on his granddaughter by touching her private parts for sexual purposes.
Totally agree. Is there anything that you want to add on?
I have a suggestion here.
Oh, please share it with us.
Yeah, sure. I think that the Act should include a new provision that prohibits a child marriage. This is because the offenders would use absence of a ban on child marriages to get away with crimes, as marital is not an offence in Malaysia. There have been several cases over the years of rapists marrying their victims, including those under 18, to avoid prosecution. In a recent 2016 Section Court case, Judge Afida Abdul Rahman had discharged a man charged with statutory rape. In that case, the judge said that there is no necessity to proceed further with the case when the 28-year-old accused had married with the victim, who was only 14-year-old. Moreover, there are 2 cases where the victim had married the perpetrator and that the marriages end up becoming more problematic and causing more hurt. One of the cases involved a 35-year-old man in Negeri Sembilan who married a 40-year-old victim with a disability after allegedly raping her. The man then reportedly raped his 11-year-old sister-in-law and faced his wife to film him committing the act. Therefore, I think that there is a need to include the provision to prohibit child marriage so as to protect children from sexual abuse.
Indeed, it is an aspect that has been missed out by the parliament. Child marriages should really be banned in Malaysia to protect all children from sexual offences. They should have been protected regardless of their marital status and work. This reminds me of the issues of child prostitution and child trafficking for sexual purposes. It has become a main concern in Malaysia recently. In the UK, child prostitution and child trafficking are criminalized under Section 74 to 51, sexual exploitation of children, and trafficking under Section 57 to Section 60 of the Sexual Offences Act 2003 respectively. In Malaysia, although not provided under this new act, we already have these protections under Section 43 and 44 of the Child Act of 2001 that outline the acts involved in exploiting a child for prostitution or sexual intercourse within or outside of Malaysia. Offences related to trafficking and adoption of children are dealt with the sections 48 to 53 of the Child Act. Hence, I would justify that the child prostitution and trafficking provisions are not required to be included in the current Act.
Also, I would like to bring up an extra point.
Oh, sure.
A special court is set up to supplement the Sexual Offences Against Children Act 2017. It's different from the existing Court for Children, where the perpetrators are children. The special courts hear criminal cases where children are the victims. This will expedite cases related to sexual crimes against children, as previously, the case would take up years before a judgment has been delivered. In addition, for privacy purposes, the media would only be allowed to follow the proceeding of the special court if a judge allowed them to do so. Also, the media would not be allowed to enter the waiting room for child witnesses. Further, the proceeding at the special court would not be like in normal cases. The special court would separately exist for both the victims and the accused. The victims will not be able to see the faces of the accused, and vice versa when they testify in court. Such facility were crucial to provide psychosocial support for child victims. The establishment of the special court to supplement this act is similar to Chapter 7 in the Indian Law on the Protection of Children from Sexual Offences Act 2012, whereby the Indian Parliament established as a special court specifically for child sexual offences cases for speedy trial. Besides, in accordance with the Sexual Offences Against Children Act 2017, there are also the amendments to the Legal Aid Act 1971, which allow underage victims of sexual crimes and their family members to seek legal advice. The child victims can request a legal companion from the moment they enter the police station to lodge a report.
I see. All of our views are indeed very helpful. So it can be concluded that the new Act basically provides sufficient protection to the children in terms of the extra liability imposed on the perpetrators who have relationship interest with the child victims, extraterritorial application, and the consideration of capacity and evidence of child witness. Child prostitution and child sex trafficking have been protected under other legislation that is more than sufficient, in which I see no loophole in it. Special court has also been established to supplement this act. The only concern now is the child marriage that has excluded children from protection under this act due to the reason that marital rape is not an offence in Malaysia, which is a controversial issue that should be tackled by the parliament. Thank you all for coming, for your insightful opinions and coming today.
No problem.
In short, the Sexual Offences Against Children Act 2017 is considered sufficient in protecting children against sexual crimes. The inclusion of extraterritorial jurisdiction, child pornography, child grooming, sexual assault, person in relationship of trust, the capability of child witnesses are quite satisfactory as the wordings are clear. Only little insufficiency exists and it could be improved by minor amendments. However, the suggestion on the prohibition of child marriage is an issue to be dealt with in order to provide a more complete protection for children from sexual abuses.